Listen Up with Jim Potts. Listen up, business owners, CFOs, human resource managers, and all managers and supervisors. Jim Potts is answering and addressing your questions and concerns, helping you stay out of court. Furthermore, please be advised that Jim's answers are not legal advice and are only intended as a guide based on his years of experience. The phone lines are open. 1-855-4-J-POTS. That's 1-855-457-6887. You can also email us at listenup@jameswilliampottsllc.com. Ready to listen up? Here is Jim Potts.
Jim Potts back on the air. Well, we've had some changes in California that have been consistent with some changes throughout the country, and actually some other states as well with this last election. I got an email, and the question was posed to me because in California there was a state measure called State Measure 64, which legalized recreational use for marijuana, and in general, it just legalized marijuana. Medicinal marijuana use has been in California since 1996, and I'm going to come back to that because that's going to be pertinent to the end result of what we're going to be talking about today. And basically, is what I received was an email asking me, how did the fact that legalized marijuana was approved by the voters, and what happens with that in terms of workplace policies. So they wanted to know, are the workplace policies basically void at this point because marijuana has been legalized in California? Now, let me just tell you something. First of all, I don't normally express hard opinions. Well, maybe sometimes I do actually, but I'm going to express an opinion. I didn't vote for marijuana being legalized. I think there's a lot of issue with the use of marijuana. I think it's a gateway drug, but that besides the points. I know that these marijuana supporters are out there, and they think that that being able to use marijuana is a good thing, and it's not a bad thing. Now, I will tell you, back in 2014, when Colorado first passed this, or they were getting ready to pass it, I wrote a white paper talking about privacy rights versus workplace rights. And I went into very great detail, offering opinions and court decisions, etc., on why, in my opinion, that was not such a good thing. And now here it is 2 years later, and the California voters have approved it. And it's been on the California ballot in the past, several times. And this time, they went ahead and they passed it. Now, let me just tell you, with recreational marijuana now legal in California, many employers are wondering how this impacts their drug-free workplace policies. This is not something new. There is a concern here. Their response to an applicant or employee drug test that is positive for marijuana, period. If they will be able to still continue to test. So you have to understand that. Contrary to what many employees likely will believe, the new law does not restrict employers' rights to continue enforcing the policies that prohibit marijuana use. Now, I'm saying that for a reason, because for you supporters out there, if you go back and read it, other than just the fact that you just voted for it, I want to point something out to you. The new law expressly states that it should not be construed or interpreted to, number one, restrict the rights and obligations of the public and private employers to maintain a drug and alcohol-free workplace. I'm going to read that again. It's interpreted to restrict the rights and obligations of public and private employers to maintain a drug and alcohol-free workplace. Now, the reason I'm telling you that, because you notice I said public and private, you have to understand about restaurants also. I just learned recently in Colorado they're taking this to a new level. Because what are they doing now? They're coming up with a chewable marijuana. So that now in the bars and the restaurants in Colorado, they can still use it as long as they do it by consuming it orally. And then in addition to that, they're also looking at these smokeless cigarettes so they can put it in there. So as long as whatever they're smoking is completely contained, that they would be able to do that as well. I personally think this is all ridiculous. Now, the law also requires an employer to permit or accommodate the use, consumption, possession, transfer, display, transportation, sale, or growth of marijuana in the workplace. What are they telling you by this law? This is specifically being spelled out by the new regulations that, in fact, that the employer has these rights. They also stated that it meant to be interpreted to affect the ability of employers to have policies prohibiting the use of marijuana by employees or prospective employees, or prevent employers from complying with the state or federal law in this area. So what we're saying here is that when they created the law with the understanding that employers were not going to be restricted by the law by marijuana being legalized. Now, let me just tell you something. This isn't new for California. California is actually the leading state in this area, because back in 1996, this issue was presented to the California Supreme Court, and it eventually went to the United States Supreme Court, because an individual had, for medicinal purposes, felt that he should be able to use it, and when the employer tested him, he tested positive, they tried to sue. And it went to the California Supreme Court and the United States Supreme Court. And both of those courts held that an employer does not have to honor medicinal marijuana certificates. Now, just because it's being legalized now doesn't make any difference at all. And I'm going to come back to that in a second. Colorado has had their first case that has now gone to the Colorado Court of Appeals, because all of these people running around out there that think that they went ahead and voted for it, now I can smoke marijuana. Guess what? The Colorado Court of Appeals told that employee they're out of luck. That, in fact, an employer can still have a zero tolerance policies. If you look out there, for some of you that haven't been to the blog, on my blog a few weeks ago, I actually did a memorandum that employers can actually print out and use for their businesses. And in the memorandum, it specifically advises employees that for them to understand that even though marijuana has been legalized, that they can still have a zero tolerance policy, and that in fact, if they violate the policy, they can be subject to termination. Now, let's talk about why, because some people out there are confused, is that if it gets legalized, why is there an issue? This is the reason why. Because under federal law, marijuana remains a Schedule I drug that is prohibited under the Controlled Substances Act. Go do your research. It's there. I'll get back to that in a second. The California Supreme Court held in 2000, and as recently as 2008, in Ross versus Raging Wire, that an employer lawfully may enforce a policy of refusing to hire an applicant who tests positive for marijuana, even if the employee was using the marijuana for medical purposes, as permitted under California law. That was the law I had told you about earlier. All right. So they dealt with this case again. The expanded legalization of marijuana for recreational use in California does not change the legal analysis in any way, because marijuana still remains illegal under federal law and in most states. Employers are entitled to continue maintaining policies prohibiting the use of drugs classified as illegal under federal law, and to enforce those policies equally as applied to applicants and employees regardless, okay? Whatever, if it's medical, recreational use, or whatever. Now, the message to employers out there would be those employers who wish to maintain such policies should ensure that their policies make clear that prohibited drug use extends to all drugs prohibited by federal law, including marijuana, even though medical and or recreational marijuana has been legalized in California. Now, multi-state employers should also measure the policies against marijuana-related laws of the specific states where they employ individuals. Look, this business about the use of marijuana, the bottom line is, could you say, why? What's the big deal? Please understand something. The basic rationale of the court is that it's still a federally controlled drug. The underlying reason is the fact that they feel that it could impair a person. Now, I know the advocates are going to swear up and down, doesn't impair you, it's not like alcohol. But remember, alcohol still violates the policies, the employer's policies as well. Now, you may want to separate the two out, saying, well, it's not the same thing. Well, look, it's still a federally controlled substance. It can still impair people, is the argument. And the courts have basically found in the past that an employer has a right to have an environment whereby for the protection of their employees and as well as the individual himself. So there's people working around machinery. Something could happen as a result of them being impaired. Now, the constant argument we always hear is that, well, wait a minute. I did it over the weekend. I'm not doing it at work. We get it. We know you're not doing it at work, but you may have done it before you came to work. It stays in your system, as I understand it, for some time. And so therefore, if the employer, normally, and employers, I'll send this message out to you. 2 reasons to test for any kind of drugs or alcohol, in my opinion, if you're not sure. One is reasonable suspicion, and the other is in the event of a work-related accident. Now, in terms of the reasonable suspicion, you don't have to be professionally trained to know if somebody's under a drug or even alcohol, quite frankly, because the courts have said that you use reasonable suspicion as simply being, how do you normally tell when somebody's impaired? Well, they may be walking erratically, slurred speech, etc., etc., etc. So that's the measure that can be used supposedly without any issues at this point. But who knows what's going to be challenged moving forward. All right. Okay, to those employees out there, for those of you that passed this and thought it was a good thing, no problem at all. Just understand that you are at risk with your employer, that if you test positive for it, you can be sued. You can be fired. And I can tell you, after all these years of being in this business, I've not seen one successful case where an employee brought an action against an employer because marijuana in some form was legalized. I've never seen it. So who knows moving forward and what's going to change on that note. All right, with that last comment, it's time to close out this segment. But let me remind you that you can hear us on Facebook at Listen Up and subscribe to us on iTunes. Just look for Listen Up with Jim Potts. Or you can call us at 855-4J-POTS or 855-457-6887. Or you can email us at listenup@jameswilliampottsllc.com. We take calls every third Friday as a reminder. Okay, I'm Jim Potts. I will continue to fight the fight if you continue to listen.
Thank you for being a part of Listen Up with Jim Potts. We take your calls every third Friday at 10 a.m. Pacific Standard Time for your questions and concerns. Call us at 1-855-4J-POTS. That's 1-855-4J-POTS. Again, that's every third Friday at 10 a.m. Pacific Standard Time at 1-855-4J-POTS. Like us on Facebook, subscribe to us on iTunes, and link up with us on LinkedIn. You can also email us at listenup@jameswilliampottsllc.com. Until next time, make it a great week.